What's up, everybody? Welcome back into an episode of The Lawyer You Know. And we had the final 2 days of evidence. There's been so many weird breaks in this trial, but we're going to break down the two defense witnesses. The fact that they only called two witnesses, both of them were experts. And in my opinion, one of them had a completely unbelievable opinion in this case and would scare me if my kid was in a school that this expert worked at personally. And again, nothing against the expert personally, but I'm going to have some pretty strong takes on her testimony. And then we got some fireworks after closing arguments. A motion for mistrial that was not just a throwaway motion for mistrial, and the comments of the judge should be very concerning for one of these sides. We're going to talk about, was it a big mistake made by the attorney? What could happen? What arguments could they make against it? Whatever the verdict is, it seems like there's going to be an appeal in this case. But let's break down the last couple days of trial to see how it ended for both sides and, of course, answer your questions. Let's get to it. So I'm going to start by summarizing the first defense witness, who was Dr. Lee Hagen. He was a clinical and forensic psychologist, and he was basically the counterpart to the doctor expert for the plaintiff. But he was specifically hired to explain what a forensic psychologist is supposed to do. And by highlighting what they are supposed to do, he is basically commenting that the plaintiff's expert did not do what he was supposed to do, and therefore his opinion should not be taken as reliable to this jury. For instance, you need to look at all the records, not just the record the plaintiff gives you. You need to corroborate the self-reports of the plaintiff. You need to meet with them. You need to make sure what they're telling you is, in fact, true. And if you don't have all of the information, you really can't give that good of an opinion. And we know that there were some important, seemingly important mental health records that the plaintiff's expert did not review, which is a problem. And in my experience in talking to a lot of different jurors, because a lot of times our doctors will be treating physicians and they'll look at what's necessary for the treatment. And the other side, the defense experts, will go get all these records from all of time for our client and say, oh, you didn't look at this record. And they try to make the record from 20 years ago look like a big deal, or OBGYN record be a big deal because she didn't complain of back pain when she was there. It's like, well, she was there focused on some other things since she's pregnant or whatever. But there have been jurors sometimes that have told me, listen, that was hard for us because the expert with more records is usually more reliable. So while that might be something some of the jurors were thinking, this expert made it very clear that he was not asked to make an assessment or give an opinion on any potential mental health disorders or diagnosis that he could give to Ms. Zwerner. He was never asked to evaluate her, and he is not going to give an opinion if he did not evaluate Ms. Zwerner. And that's what the plaintiff focused on when it comes to the cross-examination of this witness. And on redirect, again, he says, I didn't need to evaluate her to give the opinion I was here to give. I said it 3 times on direct and cross. Okay. So maybe not the most important witness, but the defense is trying to pick at and, poke some holes in the plaintiff's case. Then we get to the defense's most important witness. And from my perspective, you have to agree with and understand this witness in order to find that Ms. Parker really didn't do anything wrong. And Ms. Parker should not be liable for this. She's an expert, been an expert 25 times. And in closing, the defense kind of compares and contrasts. Look, we have a real expert. The plaintiff's got a friend of a friend who had never been an expert before. She went through and reviewed all of the documents and records that she looked at in preparation for her opinion, goes through the role of the assistant principal. And then we're going to listen to her overall opinion and then how she got there.
I do.
And how much do you charge to review records?
$350 an hour.
And how much are you charging to be here today to testify in court?
$500 an hour.
And have you ever met Dr. Parker?
No, I have not.
Now we'll get to your opinions. Dr. Klinger, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker breached professional standards with respect to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She did not.
And Dr. Parker, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker was indifferent to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She was not.
That's the ultimate issue basically in the case, right? And so the expert comes on and says, I looked at everything, looked at all the statements, looked at the depositions, looked at the handbook. I know what an assistant principal is supposed to do, and Dr. Parker should not be liable. So when she goes through what the role of the assistant principal is and eventually gets to how you deal with issues, this is the part that made me cringe and like shook me to the core, I probably would go to the level of saying, if the school I sent my kids to, assuming I have a choice, right? Private school, whatever, assuming I have a choice and it's not just your zone for the school. I know everywhere does it a little bit differently. But if I had a choice to pick a school for my kids and this expert was the one in charge of how they deal with their crisis management, which she says is her expertise, and she wrote the book on it and she trains schools, I would pull them out of that school. I would pick another school. I would talk to administration, see what the deal is. You guys know this. I love experts. I respect experts. I hire people to do all the things that I'm not good at because I know people have their specialties, their expertise. I focus on what I'm good at and what I learn a lot about and research a lot about. And this is a scenario where I would have no interest in taking this person's recommendations as to how she views crisis and problematic behaviors and reports and how she balances what administration and teachers should do. I'm just going to come on and say that. And I'll say it as a parent. I'll say it as a juror, if you want to call it that. If I was a lawyer, I wouldn't be interested, but it lines up perfectly with what the defense wants. In closing, the defense said, this expert usually testifies against the administrator. And today, she is testifying for the administrator. So that's my opinion. All right, here we go.
Evaluate the credibility and the appropriate course of action for response.
And does every school safety concern require an immediate aggressive response from a school administrator?
School safety concerns require an appropriate response from an administrator in the sense that it does not necessarily have to be immediate. It does not necessarily have to be aggressive. And sometimes that can be counterproductive. So if you think about the feasibility of...
Sure, I agree with that, right? It doesn't always have to be aggressive. It doesn't always have to be immediate. Sure, of course, we all agree with that. Let's not forget why we're here in the context of this case.
Every time a person discloses something, that we go to the nth degree and we're going to immediately lock down and we're going to immediately do some dramatic response, you would never have school. You would be clearing.
What if somebody says, I see a gun, or this kid has a gun, or he has bullets in his pocket, or he threatened to hurt me with it? How about that? Is that enough to maybe stop school? Can we stop school and search him, or maybe isolate the kid? Is that possible?
Classrooms all day long. It would be impossible for a school to function. On the other hand, school administrators have a responsibility to balance those things, to be able to get intelligence and information and make informed decisions about what the most appropriate course of action. Because
to get intelligence and information, they have to do something. And in the plaintiff's closing, they said, and we're going to break down the closings, but in the plaintiff's closing, they said, you can't just sit on your hands or bury your head in the sand and then use it as a defense at trial. Even this witness said, you have to go get information and intelligence.
Think of the nature of a school where everyone runs around totally in crisis all the time because every threat is being treated exactly the same, and we're going to DEFCON 5 on every single threat. That's
every threat. Now, again, words are important and definitions are important. How are we going to define threat? Because if we're talking about the threat, in this case, I think it should be serious. If somebody calls in a you-know-what threat, I think it should be taken seriously. Like, what threat? Explain to me some threats that shouldn't be taken seriously. Even a student threatening to beat up a teacher or punch a teacher, I think should be taken seriously. And that student should be disciplined and maybe removed from the classroom. I don't understand. This witness frustrated the crap out of me as like a human being. And I realize sometimes that happens in other cases where it doesn't affect me like that. But if I was a juror on this case, listening to this witness be so flippant about what we're dealing with here, I was like, everything can't be DEFCON 5. It's a 6-year-old. What can a 6-year-old really do? Am I the only one that thinks it's not that crazy for a 6-year-old to do something like this in America today? Maybe I'm so screwed up from like the stuff that happens in the streets and schools and churches and everywhere in America with all the problems that we have and have had over the last 15, 20 years, however long it's been. Like, it does not seem that crazy for me. Like, it's it's an overreaction to go DEFCON 5 when we have this type of a threat for somebody that everybody says is a troubled student. And I don't want to like put it, on young kids that are troubled kids, but it's like more should have been done. That seems like easy. The levels of indifference and the legal arguments as to did she undertake that duty? Was it relied upon? Fair game. Even the amount of damages, fair game, right? You don't have to just like agree with what the plaintiff said, but this expert acting like this was no big deal and, nobody should ever have to do anything with the information that Dr. Parker had makes me want to get up in front of like the legislature and be like, we need to change the rules for what needs to happen in school when this type of a threat is done. It's like saying, TSA, all the stuff we have to do at TSA, don't you guys think it's overboard? Like every single person that's getting on a plane shouldn't be created. Those threats shouldn't all be taken the same. Come on. Do I have to take my shoes off and my belt off?
Not safety. That is constant panic. And it also actually can make the school less safe because people become numb to it. You get into a boy who cried wolf situation where people are going, it's just another one of those. It's just another one of those. So the appropriate response, a measured, appropriate analysis of the information and the situation is really critical to keep people safe.
And Dr. Klinger, can you...
Of course, I agree. An appropriate response is important to keep people safe. Then she basically goes into pointing the finger at everybody else, which again is fine. To say, this person knew, this person had information. Ms. Zwerner did not do the right thing. And we know 1% contributory negligence on her and she can't recover. I think that's fair. To say she didn't do enough, fine. That's a fair legal argument. I don't know if I agree with it, but I think that's a fair legal argument. She blames Kovac, who had a lot of experience. She repeats a lot of what Kovac testified to. They tried to get into more of what Kovac said, but the judge didn't really let them. All the teachers could have called a lockdown. None of them did. She made it seem like, the teachers had a lot of authority that I'm not sure anybody else has really testified to. Like the teachers that came and testified, I don't really think they seemed like they had authority to just search the student or call a lockdown or do some of the things that she said maybe they should have done. And then, so then she goes into being cautious for body searches, which guess what? We all agree with that. You shouldn't just flippantly search children at a school. No way. But there's a reason you have a less of an expectation of privacy at airports, at schools, and it's there for a purpose. And I would argue for this exact purpose when you have the accusations and the comments made about a student, like this is the prototypical, like textbook reason why you should search a student. Let's listen to her explain.
Be in your experience that a search of a student is something that could be cautious if you're looking for a weapon?
Well, we should always be concerned about the search of a student, regardless of their age, but certainly, and that is not something that any school administrator should enter into lightly. But I think it's really important to think about this.
She makes comments like that. It makes me think, and maybe I'm taking it a bridge too far, but what I'm picking up, and I think what the defense lawyer wants me to pick up is you can't just search students flippantly. And if she didn't say this is what I'm picking up. And if Dr. Parker would have searched JT, it would have been going too far with the information that she had. It would not have been appropriate. She didn't need to search him. That's what it sounds like when she's giving these like examples and generalities of, oh yeah. We want to respect people's privacy. Of course, I agree with that. But this is the moment that we need to search.
It's a 6-year-old. This is a little kid. And
I don't care. I don't care. Has nobody ever had like a little kid do something stupid or bad or dangerous? Like when Maverick was 6 years old, like he was jumping off crap. He would jump on, he'd break my neck. If I saw him up on the counter watching wrestling and about to jump on my neck, I'm like, yeah, he could jump on my neck and hurt me. Yeah, he's 6. Yeah, it might not hurt. But it's like 6-year-olds can still do things to hurt people. 6-year-olds can still do stupid things. They can do things accidentally. Their brains are not developed. They might not even realize what they're doing. But to act like they don't have the dexterity or the ability physically to do something that could hurt somebody with those types of allegations, to me, that misses me completely, that argument.
We are going to do just at will start doing body searches on kids. That's not any kind of...
We can't just at will do body searches on kids. Who is saying to do that? Who's saying to just search every kid at will? So they're twisting the argument. The plaintiffs are arguing with the information she had, it was reckless disregard for the safety of everybody in that school for Dr. Parker not to search this one kid. Not to not search every kid, but that's what she's making it sound like, is like, hey, we can't search every kid. Come on, we got to have school at some point.
But I think it's really important to think about, this is a 6-year-old. This is a little kid. And we are going to do, just at will start doing body searches on kids. That's not any kind of endeavor that anyone should do, especially when they don't have a good amount of intelligence or information that would support that at that point.
Then one of two things is true. One, you're just dead wrong and she should go search him. Or two, go get more intelligence and information.
Dr. Klinger, do you have any opinion on whether Dr. Parker could have foreseen JT's actions that day based on the information that she had?
I think it would be difficult for...
I don't, that seems like rank speculation and getting into somebody else's mind. Could she have foreseen it? Of course she could have. The question is, was that foreseeable? But whatever.
For anyone to have foreseen that. I think the actions of everyone involved indicate that they were doing an analysis, but yet that they did not perceive this to be a plausible, imminent threat, both the behaviors as well as the actions, because it is a 6-year-old having access to a weapon and bringing it to school, and it is largely unthinkable and certainly unprecedented in terms of the outcome.
And Dr. Klinger, did you?
So, and it's also another weird thing for them to continue to be able to argue like, oh, it didn't happen, doesn't happen a lot. I feel like that's not a proper argument, because I don't think the plaintiff side would be able to be like, this is the 36th school shooting that's happened, or, like to compare the numbers, but that's kind of besides the point. From the way that they're explaining this on the defense side, to say that no one could have foreseen this, okay, I think this is a dangerous argument. If you're on the jury, okay, let me know in the chat. I'm going to be scanning the chat. Ashley asked, can we do a poll guessing the verdict? Yes, we will do a poll a little bit later in the episode once we are done with closings. MCKT, thanks for gifting 5 Lawyer memberships. But let me know in the chat, if you're sitting on the jury and they say nobody could have foreseen this, what's the first thing that would pop into your head? Because maybe I think too much of myself. Okay, it's possible. Issues with pride, working on it. You guys are always helpful to me, right? Keeping me humble. But in my head, I would think I could have foreseen it. If I would have heard those complaints and those issues with the troubled kid, I could foresee something bad happening. So if I, as a juror, am thinking I could have foreseen it, and I'm a lawyer, I'm not a assistant principal who's got this training. So if a juror thinks I could have foreseen it, that's really bad for Dr. Parker. Really bad for Dr. Parker. Okay, then we get to the cross. Assistant principal, she agrees, can't just sit in their chair and do nothing. But she also says, well, the assistant principal can't go to every door and search every bag. He literally said, by the way, this lawyer, the young male lawyer on the plaintiff side is by far my favorite lawyer in this trial. I love the way he argues. He's also the one that may have made a very, very fatal error at the end of the case, which we're going to talk about. I want to get through this because there's a lot I want to talk about with you guys. So hit the like button if you're cool. If we go maybe a little over an hour, probably not a ton over, but I think we might go a little over. He literally says, cool. When she's like, they can't go to every door and search every bag. He's like, cool, cool, cool. What about the bag of the one person that was reported to have a firearm in it? Can we search that bag? Because that's what they keep doing. They keep saying stuff like, oh, what is she supposed to do? Search every kid in every bag and knock on every door? No, nobody is saying that. Then she keeps trying to blame Kovac, which you can start to understand why Kovac really flipped and didn't seem to like the defense. I thought she was the one witness. The jury may have been like, man, she really seems to hate the defense. She kept saying things like, Parker didn't know this, Parker didn't know that. And the lawyer's like, how do you know what Parker knew? And then he goes through this scale of like a 1 out of 10, 2 out of 10, 3 out of 10. Every time she got, somebody told her something, would it go up? And we're going to listen to a little chunk of the cross here.
Would have capabilities to use it, would have the capability or the forethought to bring it for threatening purposes, which might speak to your concern about safety. I mean, if we want to just go statistically, how many 6-year-olds have you seen walking around with a gun versus how many 17-year-olds have you heard having a firearm.
If you want to talk statistically, we can talk about the CDC's investigation into accidental shootings in elementary school students in 2023. Did you review that finding of the CDC?
This struck me as something that maybe they talked about before and we're not allowed to get into. And then she brought up these statistics. So he kind of started talking about some of these statistics and then he kind of moved on and kind of gets shut down. Not as much, but it struck me just as a lawyer knowing like we're trying to get this stuff in and they're trying to block this stuff. He was ready to pounce with this. He's like, they had done studies about shootings in elementary schools. Have they not, ma'am? And why would they do studies and research on it if it's something that was impossible to happen and you could never foresee? Peter, in some schools, they have metal detectors. Yeah. Yeah, exactly, Joanne. Like this is not, it sucks that this is a reality of the world we live in. But if people are sitting around and act like this could never happen, it blows my mind still today that people sit around and think this could, like the church I go to, they've got armed security. They've got real police officers there. Right? And it's like, well, we shouldn't have to worry about that in church. We do. We do. I hate it. Just because I wish something wasn't true doesn't make it not true.
For this case, no.
Okay, you are aware because you work with the Department of Homeland Security that the CDC did perform an investigation into the prevalence of accidental shootings in minors, specifically children of the age of JT, correct? You're aware of that as an expert, aren't you?
Aware of that study or aware of it in this context? I did not review it for this case. And this was
She looked over at the defense counsel as well when he's asking these questions.
You were asking me questions not about an accidental shooting. You were asking me about foreseeability.
Foreseeability of a threat on campus.
Yes.
If there's a gun, true?
Yes.
And whenever there's a gun, especially at an elementary school, an accidental shooting is a threat, true?
Yes.
And so at the time,
I do like how he talked a lot about accidental, right? Because that's a reality too, as to why you should search, separate, take it away, whatever. Because it's not just intentional.
that Mr. Sims goes and talks to Dr. Parker and is continuing to ask about a search of the person, it's still, in your view, it's a 2 to 3 foreseeability of a threat at that time.
I'm
going to jump ahead a little bit to, he continues to ask each step, like Rawls asks, Sims asks, all these people ask, where are you at? And she really tries to keep it low at a 3. And it's like, yeah, miss me with that, ma'am. I'm not interested in your crisis policy, because it's a situation where nothing gets you above a 3 then. And somebody said, Miranda said, this situation is basically the definition of reasonable reason to search. If not this, when would be appropriate? Exactly. Reasonable suspicion. Okay, then we're going to jump over to her kind of explaining what an overreaction is versus an underreaction. And he did a really good job locking her in. And then I feel like he let her go at the end. He didn't go into the underreaction as much as I wanted him to.
At an elementary school, what's an overreaction?
Well, I think that you want an example
Hold on. I think he asked. Yeah, here we go. Back it up just a little.
about it, an overreaction, underreaction to a crisis event. But yes, we could specifically talk about to a gun on campus.
Well, that's what we're talking about in this case, aren't we?
I just want to be clear that when I spoke about it, I speak about it in general.
So what is an overreaction to a gun on campus at an elementary school? What's an overreaction?
Well, I think
Please explain to me, what would be an overreaction to that? And she's going to explain it. And I'm like, okay.
that you want an example of it, you mean?
Yeah, I mean, you're saying you have to weigh the balancing test. What possibly could be an overreaction to a gun on campus?
So you want me to take it to the biggest overreaction I can think of?
Sure.
That would be when a student indicates that another child has something.
Yeah, but we're
weapon.
talking about overreaction, underreaction in terms of responses, correct?
Are you asking me when it is already proven that there is a weapon on campus, or when there is a suspicion of a gun or a weapon on campus?
Which one?
She keeps trying to use weapon, because weapon doesn't always mean firearm, obviously. The quibbling with that he also deals with in closing a little bit, but you can tell she's quibbling there.
Applies here.
Which one applies to your questioning?
Which one applies to this case? A suspicion or proven? In your view?
There was a suspicion that the student had a weapon of some sort.
Of a gun.
Students use the word gun, yes.
She used the word gun.
in her statement, yes.
Oops, let's just use her word. And that's another issue if I'm the defense. Remember this, okay? Because when we're going to talk about the motion for mistrial at the end, the fact that they did get a lot of Dr. Parker's words in, not a good thing for the plaintiff when we get to the end.
So there's a suspicion of a gun. So let's use that circumstance.
Yeah.
There's a suspicion of a gun on campus. The assistant principal recognizes there's a suspicion of a gun, and for 2 hours, the foreseeability that the gun remains on campus is not zero. It's something more than zero. That's what we've just gone through. True?
Yes.
What's an overreaction in that context?
In a elementary school where there is the suspicion that a 6-year-old has something,
We're not talking about something. We're talking about a gun.
that a 6-year-old has a weapon that students
She just can't do it. She just can't. And it's frustrating. You got to be careful how much you go after them. But like, oh boy, does she not want to say it? And that's the point. She's proving the point of how I am seeing this case after all the evidence is presented. The words and the timing of what was said to Dr. Parker, she was absolutely showing reckless disregard to do nothing, to not search the kid, to not get out of her chair and go get more information, to not allow some other teacher who has a relationship with this kid to search him, who wanted to search him. Even though he didn't even think it was possible, he still wanted to search him, Mr. Rawls.
We're talking about a gun.
that a 6-year-old has a weapon that students have
talking about a gun.
categorized as a gun.
We're talking about a gun, man.
Do you want me
What is an overreaction to a gun?
an example of an overreaction is that when a student says student X has a gun, that we call a lockdown, we have an active shooter response, we search the kid, we put him down, we put him in cuffs, we drag him off until we can figure out that he had a Nerf gun or a squirt gun or a firearm.
So you agree that
Okay, so she says that's an overreaction. We throw him on the ground, we cuff him, we lock down the school, we call law enforcement in. Sure, okay. This is just between us, okay? Just between us girls. I would rather that, right? I'd rather the overreaction than the underreaction and something like this happen. But I get it. I agree. That's an overreaction. Guess what? Not what anybody said they wanted here. Nobody said lock down the whole school, active shooter plan. Nobody said that. We want to look in the kids' pockets. That's it. But I thought it was really smart for him to highlight what the overreaction is. I wish he would have done better about the underreaction. Sherry, thank you for gifting 5 Lawyer You Know memberships.
Mrs. Zwerner wasn't expected to just drag the kid out of class, call a lockdown, and do all this stuff. That would be an overreaction.
An underreaction would be
Stay
to
with my
leave him
question.
in the student
Stay
in
with
class.
Stay with my question. You agree with that statement that I made, correct?
No, I do not. An overreaction, it would be an overreaction to tackle the student, get the police, yes, all based on somebody said he has a weapon or what small children call a gun.
So let's talk about underreactions. Underreaction is an assistant principal not calling 911. True.
Well, can I finish answering your previous question?
You didn't answer my previous question. You went on to your own question.
Well, no, I was trying to answer the question of you.
That could have been objectionable, but he's right. She's like not answering the question. Joby said, I'm disagreeing with the majority in this trial. I would not find Parker solely liable. So this is a great comment, Joby. I appreciate you giving this comment. You don't have to find Parker solely liable. Was she acting with reckless disregard or indifference? You could still think Kovacs screwed up. You can think Rawls screwed up. Now, if you think Zwerner is at fault, then she could potentially lose, the plaintiff. If she's 1% at fault, they mention it in Virginia, for that contributory negligence, she's barred from recovery. But if you don't think Zwerner did anything wrong, the question is about Parker. And they're not pointing the finger at Kovacs and Rawls and everybody else to say they're all at fault. The reason the defense is pointing the finger at everybody else is to say nobody thought this was credible. Nobody thought this was foreseeable. Nobody thought this was real. So that's an interesting point that maybe the plaintiffs didn't harp on enough. That it's not about multiple people being at fault. Was Dr. Parker responsible? Because sure, if you go back in time, a lot of people could have done a lot of things differently, right? Mrs. Zwerner could have stayed home from school that day. But was that the but for cause of this happening. And you may still think that Parker is not responsible equally as everybody else is not responsible.
Asked me about an overreaction, and then you brought up Ms. Zwerner as an overreaction, that she didn't drag him out.
Correct.
Did you? That's what I understood you to say.
And you agreed that you wouldn't expect her to do that.
But a student can be removed from a classroom without being dragged, kicking and screaming.
Right.
A student can be isolated. A book bag can be moved without it becoming an altercation or an aggressive or violent incident.
All things
that would be a more appropriate reaction. So I just wanted to clarify the overreaction that you asked about.
All things that Dr. Parker did not do. True.
All things that Ms. Zwerner did not do either, or Ms. Kovac didn't do either, or Mr. Rawls didn't do either, because in their judgment, it was not an appropriate measure at that point.
That's why she said none of them did that. That was perfect. Perfect timing, right? I love it when it works out like that. So it's not to say everybody's at fault. It's that nobody found this to be credible and legitimate.
Let's answer my question.
Okay.
All things that Dr. Parker did not do. True?
All things as in remove him from the room?
Correct.
Yes.
Okay. Now,
That's the point. See how he's not trying to focus on everybody else. Dr. Parker didn't do any of the things you said would have been appropriate. Not the overreaction, but the appropriate thing to do. Not that it can be considered in trial, but liability gets cloudy for me when I ask if it were a child who was injured, I'd blame all parties. And that's fine, but what's before you today is Dr. Parker. That's what I would argue. Who's before you today? Dr. Parker. Because we've seen lots of cases where there are multiple defendants. You might not know what's going on in the background. You've got to decide if Dr. Parker is at fault. Ladybug said, I was shocked at the news this happened because a 6-year-old. Watching the trial made me realize how it could have been prevented. Team Abby. Karen, in my third world country, buildings, including high school I went to, have metal detectors and security guards who check your handbag upon entry. And then the second part of the comment, it seems so nonsense to us, all this hassle over privacy versus safety, with all due respect. There is a balance, right? There is a balance, just like they're saying. I'm not saying they got to search every kid, but this is pretty much feels like the right time for it. I'm never going to get through all this. All right, let's jump to closings now. So the plaintiff's attorney, this plaintiff's attorney here, I got to learn his name, is the one that gives the closing argument for the plaintiff. He didn't do the opening. The female attorney, who I thought did a good job in opening as well. She hasn't done a ton of witnesses, but his theme is kind of minute by minute, or minutes matter, and a gun changes everything. And from my perspective, it is a good theory. It's gripping. And I think that you can tell he waited until the evidence came out before really putting his closing together, which is, I think, the best way to do it. You can kind of have a structure and know some of the things you want to do, but you really should pull from the trial so the jury knows you were paying attention to the same stuff they're paying attention to. And to say a gun changes everything is important based on that last expert and multiple people trying to say stuff like, oh, well, it was a weapon, or it was bullets, or, we don't really know. Then he talks about fault, blame, and cost, which I really like. You got to create that roadmap so they know. He talks about, so I like this. You guys know what I say closing arguments are all about. Closing arguments are not just restate all the facts that happened. Closing arguments are to arm the jurors that are with you and see the evidence your way and agree with you. And you guys all have the same definition of justice in this case. Give them the ammunition they need to go back there and fight for your client. And that's what he's going to do. But I do think he almost focused on it a little too much. Like he's going to quickly go through the facts. The defense mentioned multiple times how the plaintiff just wants to gloss over the facts in this case, which I don't think is actually correct and not what he meant. I actually agree with what he meant. You guys sat here. Wasn't that much testimony. It wasn't that much evidence. I know we're, a week into the trial, but 2 or 3 days, we did nothing. There was not that much evidence in this case. This should have been a 1-week trial. There's no doubt in my mind. This should have been 5 days. And this case should have been done. But there were all these delays and days off for whatever reason. He talks about fault and how Dr. Parker had a job and we rely in this world on people to do their job. He quickly recaps some of the facts. He explains the difference between negligence and gross negligence. I'll throw a baseball here, or if I throw it through a crowd of people and think I can get it through them, like that's gross negligence. I'm not that good at baseball. The analogy was fine. It wasn't my favorite analogy I've ever heard, but I think they got the point. And then he talks about, again, you can't bury your head in the sand and then use it as a defense at trial. What else do you need? A gun changes everything. Bullets shoot. Come on. Firearm. Come on. Messing with the words. And then he deals with one of the very big defenses in this case, which was hindsight is 2020. And I do think that this was important for them to hit. Sandy said, plaintiff used too many slides, metaphors, and repetitive scenarios. He lost me after 20 minutes. Fair critique, and I want to know what you guys think as well. I thought there were some really, really great moments of closing, some highs, but I did think some of it felt a little scattered. And those PowerPoint usually, I'm screaming. I can feel myself screaming. Sorry for screaming. Those usually help keep lawyers structured without actually writing out what you're going to say or the exact outline of what you're going to say. The outline or the PowerPoint can help you with that. How he does his PowerPoint is exactly how I do my PowerPoint, where I don't put 1,000 words on there for the jury to sit there and try to read. I do a picture or a graph or an arrow that makes them think something, moves their eyes to it if they're visual learners. That is reinforced with what I say and what I'm showing. I also like to write something on a butcher block. I like to play a video if I can. I like to use different multimedia, but I'm glad he didn't have these paragraphs on most of his slides. And again, I listened to a lot of it, watched some of it. So maybe there were some slides with that, but what I saw, he didn't. Sport events, airports, courts, etc. have metal detectors. Why not our schools? This is where tax dollars need to be spent. Their expert is crazy. I agree that she is not solely responsible. Where are the parents in this case? They need to be held accountable for the child even having access to that. Right. But again, that's not the question before this jury. And I think they did talk about it a little bit. I probably would have hammered it home a little bit more if I was the plaintiff. But let's listen to him talk about the hindsight 2020 and how he deals with that defense argument.
Well, maybe the child said bullets. Is bullets really a gun? Ladies and gentlemen, if you have an elementary school, 6-year-olds, if we looked at the classroom walls, we're still teaching them how to use punctuation correctly and what words to use and how to capitalize letters. And you're going to wait until a boy says, no, it was a gun, it was a real gun, it was black, it had bullets in the gun?
I see a lot of people talking about the mom. I get it. And JT, you think he has some culpability here? And whatever Virginia law says about when somebody can, but for him doing this doesn't happen. But that's not the question we're here to ask. And you guys would be a great focus group. I'm just telling you, but people have asked me if I'm going to consult, and I'm like, no, not really. But if I was going to consult with this plaintiff's firm, I would have said, make sure they're not focusing on JT's mom, other people that are not the question before them today. Yeah, everybody hit that like button.
No, ma'am. Gun, bullet, weapon, firearm, we don't need to talk about what all they mean. Each of them required a response. Each of them. But what we know for certain is that it was a gun from her herself. And they're going to come up here and tell you hindsight 2020. Remember that? Hindsight 2020. It's easy to see now that there was a shooting, that we look backwards and now that we know there was a shooting. It's easy to know that looking at our rearview mirror. You don't need to look in the rearview mirror. There were road signs in front of Dr. Parker for an hour and a half, screaming at her, flashing.
By the way, you can say this is corny, and I might even agree with you. Some of it's a little, I liked this, personally. I liked this. Because this is what I've been thinking all trial. It's like, this isn't hindsight. We're looking at with one of these complaints, I would have at least let them search JT. Come on. But I agree. I can understand if people think this is corny, so it might not be for everybody.
At her, telling her exactly what was going to happen if she did not act. You do not need to look in the rearview mirror to know what's coming ahead. And the only reason it's in her rearview mirror is that she blew past the signs. She blew past the signs. Do we need?
All right, so I got to pause it because somebody just threw me a blast from the past. Pretzel said, we learning to type on Mavis Beacon now? I literally learned to type on Mavis Beacon. It's wild. It's a wild one. I find the complacency about a student has a gun mind-blowing from Australia. I know. I get it. Joy, as a grandparent raising children with ASD and ADHD, I can assure you I would have no issue with the school searching him, but the parents are guilty too. To me, the fact that it was a 6-year-old makes it even more serious and plausible. The plaintiff's attorney reminds me of a young lawyer you know. I have no idea how old he is. He's great. Like, I take that as a compliment. I enjoy listening to him. The way that he argues evidentiary matters as well, I really enjoy listening to him. I think he's great, personally.
Every letter to know what it means? Do we need every letter? They're going to tell you this wasn't foreseeable. Remember that discussion? Wasn't foreseeable that this would happen. And that's why we talked about this question of foreseeability. And I'll show you an instance.
Hey, John, you just have a way with words, man. This is perfect. Corny, yup, but it got the point across. And if I'm giving a closing argument, call me corny, call me stupid, call me whatever you want. If you're getting the point, that's all I care about. I'm doing a job for my client. I'm fighting for my client to get the point across. So corny or not, if you get the point, job well done.
Instruction on this.
Oh, so he did use the Elmo too. See, I love that. The different multimedia things that you can use to keep the jury thinking and engaged. I like that.
The defendant is not required to have anticipated or foreseen the precise injury, but it is sufficient that a reasonably prudent person would have anticipated or foreseen that some injury or damages might probably result from the negligent act. What does that mean? What that means is, and what they're going to try and argue to you is, who could have seen that a 6-year-old would pull out a gun from his pocket, point it at a teacher, and shoot? That's not the question. The question is for every moment, every minute, every second that a gun is in the possession of a 6-year-old who, I agree, has totally unpredictable behavior. If anybody has dealt with 6-year-olds, it's totally unpredictable. All the more reason to find the gun. All the more reason. That gun could have been popping up and down in his jacket and gone off. Handed it to a friend and gone off. Showed it to a friend and a book hit it and gone off. Dropped on the floor and gone off. You do not have to foresee the precise injury that was caused. Only that some injury or damages might probably result. We can go to the...
Okay. I find going over the instructions very helpful. So you got to pick and choose, right? A lot of times when I start my closing, I have so many instructions there. I was like, I got to pull some of these out or else I'm just reading instructions the whole time and that's boring. You've got to use the right ones in the right places, which I think he did right there. Chances said mom's in prison for allowing access to a gun. I have not seen that and looked into it. I see a lot of people posting that. It could very well be true. I can't confirm or deny this, but I've seen a lot of people posting that. And I have some questions already about the rebuttal closing, so I'm going to save them and answer them when it's appropriate. Okay, so now one of the biggest parts of this whole trial is how do you deal with the $40 million question? They confirm basically that they talked about $40 million in jury selection, and we're going to listen to a big chunk of how he explains these damages, because when I ask you for a verdict at the end, I want you to try to give me a range of damages.
He didn't ask, well, how much the plane cost? Or was it holding freight? Or what was the freight? Or what was in?
So I may have missed a little part about how he was talking about there's nothing more valuable than life. That's how he kind of opened this up.
The plane? First question, and the first question that each of us thinks, whether it's in our gut, in our head, or out our mouth, is how many lives were lost? And that's because there isn't a single thing on this planet that is worth more than a human life. So we start there. And then the question is, how do we count the value of a human life? Well, over time, we've come up with phrases that we use every day. We use phrases like time is money. Heard that one? Time is money. We hear phrases that...
He also asks the jury a lot of questions, which my guess is he gets head nods and expressions from them, again, making sure they stay engaged. Some judges will not let you do that.
Started in the 1600s and the 1700s that say, can I have a penny for your thoughts? Or, is it worth my time? All of these questions tell us that we understand that there is a value, a dollar sign, as weird as it seems to think about it, that we equate to our human experience, that we count in minutes, hours, days, weeks, months, years. And you heard it in this courtroom. we had experts take the stand. And they were asked, how much are you being paid for your time? Remember that? $500 an hour to be here.
So that's an inappropriate argument in Florida. I assume in Virginia it's different. I don't know. I didn't look it up. But one of the ways we're not allowed to compute damages, especially on a time frame, is to compare what the other side was paying their expert to be here. It's like they paid $500 an hour for her. Why can't they pay Ms. Zwerner $500 an hour for her pain? But I assume it's allowed in Virginia. I don't know. Ladybug said, burning question if I'm on the jury, why didn't the plaintiff address gap in use of hand, hairdresser versus opening chip bag? I would want clarity for determining money. So this is the big question here. And like I always say, this is the hardest part of the trial, because some lawyers, their strategy is to be very specific on the money, and some it's to be very vague. I think he went vague. Like, this is so bad. This is so horrible. Didn't give any numbers of like what these surgeries are going to cost in the future. Like, we like to have a life care plan. If we're asking for $10 million, it's like they have $1 million in past medical bills. They got $3 million in the future. That's $4 million. $1 million in past pain and suffering, $7 million in the future, whatever it may be, right? To explain exactly how we get there. Theirs is just kind of like this big bucket of $40 million that, I mean, I guess if the jury's fully on board with them and they're like, this is horrible, Dr. Parker screwed up so bad and what happened to Ms. Zwerner is so horrible. Sure, you asked for $40 million. I'm giving you $40 million. That's kind of the strategy I think they're going with. That, or they don't really care. They're like, as long as it's a big number, we don't really care if it's $5 million, $10 million, or $40 million.
Dr. Klinger took the stand for about 2.5 hours, more than $1,000, sitting in this courtroom, talking about life experiences that she lived. And nobody blinked an eye. We understand, whether we ever think about it or not, that there is an equation, that we can equate human life and our experiences to dollars and cents. And it's my job to try and talk to you about that, and it's ultimately your job to decide how much it's worth. So, the jury instructions will tell you.
Freedom Ring said, was the coworker sued because work comp immunity protected employer from suit? CGL policy doesn't cover co-EE injuries typically. I have no idea. My first experience really with this case was opening statements. So I don't know any of the procedural history here, who was in, wasn't, and why.
Some damages to think about. And when I say that, I mean these 4 things right here.
I love that he uses buckets, because I use buckets all the time when I talk about stuff, like buckets of money or buckets of damages, and that's how he's going to explain these buckets.
And we'll take them in order, and I'll tell you that I'm going to merge some of them. So we're first going to talk about bodily injuries, disfigurement, and deformity. The law says that if she is entitled to recover, that is, if Ms. Zwerner has proven her case, that she's entitled to recover money for each of these elements. So why did we put on the evidence? Why did we, if we can go back, put on the evidence of these 3 doctors and other doctors that came before you? Is to show you the injuries. To show you the injuries so that you could understand, based on the jury instruction, how bad, how severe, and
I'm going to skip a little bit of this just because it's pretty long, but he goes through the injuries again. He shows the really great demonstrative aids that we got from the doctors, 2 centimeters from the heart, the hardware that's still in her hand. He did a really good job explaining how those injuries are difficult, but I don't want to rehash all of them here just for time's sake.
Don't we know that even every moment she goes into the doctor's office and has concerns about what her medical condition might be, and she has to tell them, I've got a piece of metal 2 centimeters from my aorta, I can't have that test.
He also talks about like what it means mentally, right?
And somebody might say on the other side, it's just a hand. It's just a hand. Is it? Is it when you return home from surgery in the hospital and you're with your mother, and we're talking about disfigurement and deformity, and you can't move your hand, and you can't bathe yourself at 25 years old? You can't use the restroom by yourself.
I had a horrible leg injury in high school, and same thing. My mom had to do all this stuff for me, and it's the worst. It's the worst. And it's like these life experience jurors bring in. If anybody has ever had a surgery or an injury as like an adult or semi-adult, and it's like you got to have your mom do all this stuff for you, that sucks. How do you put a money figure on it though, right?
Are we just talking about a hand? Or are we talking about what it is to have dignity and be a human being? The element of instruction talks about mental anguish. It talks about physical pain and mental anguish. But I'll tell you right now, physical pain, she felt more than anyone could ever imagine. I promise you that. And we showed you videos to try and tell you and show you exactly what it was like. But even when the pain goes away or goes down, this doesn't. This keeps going. And we heard from Dr. Watson, and we spent time talking about re-experiencing. Do you remember that? And I had a roadmap stop with Dr. Watson that said brain and body. Remember that? Brain and body.
See how he raised his hand? But that's also why he uses those like roadmaps, demonstrative aids, so he could call back to that when talking to the jury to help them remember that, because some people can put that together with the way they remember things. A lot of strategy, I'll just tell you, and technical moves by this lawyer throughout the trial.
Why did we talk about brain and body? Because you don't injure part of a human being. You don't just injure a hand.
So not to mention the money for all the surgeries. I don't know if they're asking for that. I didn't see like a past medical bills number that they produced here. So I think it's just pain and suffering. I don't think there are actual compensatory damages for medical bills. I don't remember seeing that or hearing him argue about that. So it's not necessarily something that's coming into play here.
Or an arm. You injure all of them. You change all of them. And what we heard about and what we talked about is a young woman at 25 years old, who had chosen her way of life, who had decided who she wanted to be, where she wanted to go, and the purpose that she would achieve. You heard from her sister that said she had a purpose. She knew what she wanted, and she was chasing it at 25 years old. And some may say,
I actually think the defense did an okay job of being like, maybe being a teacher wasn't her dream. But I get what he's saying. He's basically saying the choice was taken from her as to what you want to do with your life. And that shouldn't be taken from anybody.
Want to be a teacher? Really? That's what she wanted. Maybe it's because her mother did it. Maybe it's because she wanted it for herself. But that was her choice. And they'll talk to you about cosmetology school, like she had considered this beforehand. Really? Really? She chose to be a teacher, knowing full well from the experiences of her mother exactly what it meant. That it meant sitting with a printer next to you while you sat next to your sister and she watched movies.
By the way, people are saying work comp could have paid, insurance could have paid for the medical bills. Sure. And if they did, sometimes there are liens that you can still ask the jury for, and they'll be set-offs in the end. Sometimes you waive them because you would think it costs $1 million in medical bills, but it really only costs $10,000 or something. The number's so small, you want to waive it because you don't want the jury to see such a small number of medical bills and that affect the rest and anchor, as we say. But I don't know.
That it meant late nights, that it meant early mornings, that it meant difficult times with your students, that it meant being around them and shaping the future of our country. And I'm not saying that to you to tell you that being the teacher is the most valuable thing in the world. What I'm telling you is that it was her choice. It was her choice, and her choice to be what she wanted to be is changed and taken from her. What do we value that at? What do you value it at when you decide this is who you're going to be in life? And through no fault of your own, against your will, and without your consent, that's taken from you. That dimming of a light of a young woman who used to pop at you with color. That numbing of life's experiences. Numbing of it. What is that? That's not every couple of months. I told you I would repeat this. Every minute matters. Every minute matters. When you change a human being, when you change who they are, and you rob them from the control to decide who they will be in the future, you've changed them forever. You've transformed that person. And the Abigail Zwerner that sits here in front of us today, on this day, November 5th, 2025, is not the same Abigail Zwerner that walked into the classroom on January 6th, 2023. Does anybody have a doubt of that? It's not the same person. I'm not saying it's no one anymore. I'm not saying she's any less of who she was. What I'm telling you is that she's been changed and she didn't want to be changed. And what damages do you arrive at? What number do you arrive at for somebody who didn't want this and it's been inserted into her life like a bullet fragment against her spine?
Get it? Using that illustration, an analogy.
Every minute matters, right? The light that was in her life when we showed that video. I asked her to step out of the room because she doesn't need to see the video to know what that was like. That was her life. She lived it. And just like it might be burned in your memories, do you think it's not burned in hers? And when you think about moments of compensation, what is fair? The question that I asked you to determine is if in that moment, and if in that moment someone came to Ms. Zwerner and said, Abby, this is what you're about to experience. This is what we're going to put you through. There's going to be a boy's face you'll never forget. It's going to come to you when you don't want it to. And you're going to be walking down a hall, and you're going to be thinking you're on your way to heaven. And then for a moment, you're going to think you're not going there. Until you're shocked back to life with the pain and pressure of a colleague trying to save your life. If I stopped this case right there, if we stopped it in that moment in time, at 1:59 in the afternoon on January 6th, do you think that Abigail Zwerner would trade any amount of money and say, yeah, I'll go ahead and experience that? That moment that I thought I was not going to heaven, that my faith had failed me. I'll trade that for $10 million? Do you think she would trade it? She wouldn't. She wouldn't for a moment.
I think that's a good argument too, because some jurors think of things like that. Chronic Christie said, don't think he was using money for experts to compute damages. I think he was still explaining how to equate time equals money. So how he explained it is almost in the case law in Florida, as to say what you're not supposed to do is to like frame the value of time and money. Can you talk more about damages in Virginia? If a jury finds her 1% liable, she can't collect. Hard to imagine Abby has 0%. She could have searched him. No. So again, that's going to be up to the jury, but that's how it is. What I do like is that Virginia allows the lawyers to say, if you put 1% on Abigail Zwerner, she is barred from recovery, so that the jury doesn't think, we'll just put 10% on her. We've had juries do that before, put like a small percentage on our client. You know, it didn't matter in Florida back when we had a certain law that's now different. We're still not to the 1%. We can talk about that another time, but you got to make sure the jury knows if you put even 1% on Abby, she loses. So you as a jury have to decide who wins and who loses. And sometimes you can fix that problem because that's a horrible rule. Could you imagine somebody being 95% at fault for destroying your life? And it's like, nope, you can't collect anything from them. I mean, that's just lobbyists and money creating that. Normally in medico-legal, the biggest money indicator is all about future loss of income and future medical expenses, mostly until retirement age. I disagree with you. A lot of times the pain and suffering can be the biggest money driver for juries. Now, for adjusters and lawyers to put money on the case, yes, I would agree with you. Medical bills and lost income, those are almost the guarantees. But the big numbers that can really scare defense lawyers and that jurors really feel sometimes, depending on the case, can be pain and suffering. And a lot of cases don't even have loss of future income if they're already retired or, are able to supplement that somehow or have disability insurance or whatever it may be. But every case is different. Honestly, every trial I have is very different. Whether you can have 10 car accidents in a row that are all very different.
But your job is the difficult one, which is to say how much would be fair in full if she had to take a trade. If a trade was forced upon her, what would be the fair amount of money? Because that's what's happened. It was forced upon her, and you have to decide how much would be close. And not just for that moment, but for the next, and the next, and the next. And the moments where she wakes up in the middle of the night, thinking of that exact moment, reliving it again, like it's playing on the screen in front of you and she doesn't need to see it. What is that worth? There are some holes. I told Ms. Toscano not to get too close to me, but it reminded me of something. We've all had that moment where you're getting a cold. You can feel it coming on, right?
I liked this analogy as well, by the way. Christy said, would she have had to pay the medical bills in the States out of pocket, ignorant Canadian here, but she couldn't get stuck with that bill, right? So I don't know exactly how it all worked here, but she could have work comp paying it, which is a type of insurance here. You can have health insurance paying it. You could pay some out of pocket. If insurance denied some, you could pay some out of pocket. So there's a lot of different ways, and I don't know the answer of how she specifically handled it, so I hesitate to say exactly what she did.
You feel the tickle in your throat, and it's coming to you, and you're thinking, tomorrow, probably not going to feel too good. My nose is going to start to run. Next day, I may have a cough. I'm going to stay away from people. Next day, I'm going to feel worse. My head's going to hurt. But what we have when we have those colds is that we know that one day will come, whether it's tomorrow, the next, or next week, that we're going to throw our legs off of our bed. We're going to sit at the end of it. And you're going to go, it's gone. I don't have it anymore. It's not with me. She will never have that moment. As much as she wishes to escape in her dreams and escape in real life, every time she throws her legs off the bed, that will be with her forever. And every
I like that. I think that's good. Like, we know our sickness is going to go away. Hers isn't. What she's dealing with is never going to go away. The audio is a little like fuzzy for this part. So I apologize for that. So what this plaintiff's lawyer did, instead of saying, this witness said that, this witness said that, this witness said that, he said, you go back there. You make sure they don't forget about what Ms. Zwerner went through and all the signs Dr. Parker had, and she didn't do anything. Reckless. She was reckless with her indifference in what she did. And now Zwerner's got to deal with this for the rest of her life to the tune of $40 million. He is empowering them to go back there and argue for him. Not, Mr. Smith said this and Mr. Jones said that. So you can do that, but I don't think that's as effective or powerful personally. It's pretty much exactly what the defense does, though.
time she sees somebody reach their hands in their pockets, which I've tried to be conscious of, will be picking a scab at a wound that will never heal. It is for all these reasons, and for all of these moments, that when you sat here a week ago, I asked you that we would be asking you for a verdict for $40 million, and if the evidence supported it, could you return the verdict? It is because she will never be the same, and somebody might say, they might say, that's a lot of money. It is a lot of money. I agree. But do you think, for a moment, she would trade it for what she's endured? If we could tell Abby to walk out that door right now, and her sister could look in her eyes and talk to her again, do you think she would trade? This is the final thing I'm going to talk to you about. And I asked you about rendering a verdict based on sympathy for her, but it's also not this calculation, and you decide what all of these harms and these losses and what's been taken from her is worth. It's not up to you to decide where the money comes from. It's up to you to decide what it's worth. What it's worth. And if you get back into that deliberation room and there's a conversation and somebody says, well, what effect will that have on Dr. Parker?
So it's great. You have to handle this too. Don't worry about how it's going to be paid. Number one bailiff said, I believe jurors in our country are instructed not to be concerned about insurance when deciding damages. They're not specific. It depends on the jurisdiction in the state. Obviously, it's different everywhere. They don't usually specifically say insurance, but they say that's not of your concern. How is it going to get paid or who's going to pay or whatever? Don't make your decision based off that.
Or how will she ever be able to pay it?
And they started kind of talking about it in defense. He objected because she was like, Dr. Parker's going to have to pay for this. And he objected, but it was kind of a nothing burger.
And if for those reasons you reduced your verdict, the number might be correct. Whatever number it is that you decide in that moment might be correct. But it would be the right verdict for the wrong reasons. Because the only reason that you can reduce the amount of what it's worth to her is if you decide it's not worth as much as what we're asking. And that's a critical point, because at the end of the day, what we want is a right verdict, but we want it for the right reasons. Because if it's full justice. Whatever full means to you, whatever you decide full is, that is full justice.
I also really like this. I've used this before.
In any centimeter or sip, less than full justice.
I probably would have said even 2 centimeters because of, the heart, how it's 2 centimeters away from her heart, the bullet.
In any centimeter or sip, less than full justice is injustice. And injustice anywhere is a threat to justice everywhere. And so when you
Even a little less than she deserves is just not justice.
decide this case, when you analyze the facts, when you consider all the evidence, and you decide what's full and what's fair, I'm asking you, and I trust you, to render the right verdict for the right reasons. Thank you so much for your attention.
I really liked the closing a ton. I do want to talk about these 2 comments. Steph said, 40 million is too much for me. They didn't break it down at all. And Kimberly said, this attorney is very articulate in my opinion, but not sure I get to 40 million. I tend to agree that I'm not really sure like they really made me think 40 million. But I think the strategy is if the jury's with you and they love you and they feel so bad for Ms. Zwerner and they hate Dr. Parker for what she didn't do and it seems so obvious and we got to protect our schools and make them safe. And you know what? 40 million. It's possible. I've seen stuff like that happen. We've had cases where we've been surprised at the verdict too, you know, and we or at what somebody thinks it is or whatever it may be. But I'm not sure they really tied anything to 40 million, right? It wasn't like this plus this plus this plus this equals 40 million. Exactly. Bobby said I'd give 100 million. And I think it's very likely a juror could be like that. All right, let's jump to the defense closing here. It's almost the beginning. I'm going to just jump ahead a little bit. Oh, no.
Thinkable, and it was unprecedented. You heard many people tell you that, but we're going to start with this person. Who was that? Amy Klinger. She's a national school safety expert. She's written a book on school safety. And she came here and she told you the framework about how decisions are made among administrators and people in school systems. And we'll get to that later. But she told you, Mr. Beniozen talked about me blaming everyone else, but she told you that everyone involved was doing an analysis that day, but they did not perceive this to be a plausible imminent threat because it was a 6-year-old. It was unthinkable and certainly unprecedented. But now we're here. We're in the hindsight phase. Criticisms to find fault. 3 years later, with the outcome known, trenches have been dug. Somebody's got to go down. We're going to blame this person for it. Dr. Ebony
Again, completely ignoring what she knew at the time.
Parker. She was the assistant principal at Rich Neck Elementary School on January 6, 2023. Talk about the issues in the trial, and I'm going to move past this quickly because Your Honor is giving you jury instructions. You're going to take the jury instructions back, and you'll see all the issues in this case. And I won't belabor this issue, but I'm going to tell you something. When you get back there, I want you to look at jury instruction number 16 about assuming a duty. And you're going to find, when you read that instruction and you apply it to the evidence in this case, that Dr. Parker did not have a legal duty to protect Ms. Zwerner. She did not volunteer to protect Ms. Zwerner. You remember the admissions in the case that we read?
So they go through the
Is
admission.
not inadequate. Different, scant care. And
So then now she goes through the gross negligence definitions from her perspective.
you might ask yourself, what does that mean? It's indifference. Indifference. And the evidence in this case doesn't show indifference. Mr. Beniozen glossed over the evidence, but bear with me because we're going to walk through it.
He glossed over the evidence case. She's going to say that multiple times kind of throughout her closing. Okay, I'm going to go through her closing. We're going to play another clip here, but just for timing's sake, I want Kelsey to put the poll up. And obviously we only have 4 options, so it's not going to be perfect, but basically it's going to be, what would your verdict be for Dr. Parker, or 3 options for the plaintiff? The plaintiff, $0 to $1 million, $1 to $10 million, or $40 million. Would you just give what they meant? If you were going to give over 40 million, just put 40 million. You get it. Whatever's closest to what you would give as a verdict. Chance said she forfeited work comp to sue the school. Not sure if she will get work comp since the judge dismissed the school from the case based on sovereign immunity. This is local for me. Okay. Abigail, I liked his closing, but when you said the other day, would you trust her at your kid's school? That moment made her liable. Is that allowed in closing? So you can't necessarily, I think it'd be touching on the golden rule, like putting the jury in your client's shoes. Like, would you want this person at your school? But I think it would have been fair game to be like, when you talk about the expert or Dr. Parker, they shouldn't be in any school in America, the way they look at threats and the way they deal with threats with reckless indifference for human life. I would make that argument, but you got to kind of generalize it versus like, would you feel comfortable to the jury? You got to be careful with that. Mary C., thank you, Peter, for bringing this interesting case to us. I learned a lot. This was a super interesting one to me. I really enjoyed watching it and covering it. And, you guys had a lot of great questions and we learned so much, and it's so different from any other trial we've ever covered. And that's the point. Let's continue to learn. Let's be lifetime learners, lifelong learners. So I appreciate you guys all showing up, hanging out, giving me your comments and questions on this. Okay, so she goes into believing, she compared Kovac, like here's the text message where she was all nice to Dr. Parker 2 days after the event, and that's a very different Ms. Kovac than testified. She's not credible. She, again, recaps a lot of the evidence. From my perspective, it wasn't that long of a trial. I don't think you needed to get quite into the weeds of what everybody said. Again, I'd rather arm the jurors with your best arguments. She mentions contributory negligence, that if Zwerner has any, it blocks recovery. She's the one that brought that up, which I thought was interesting, because I think if you want to make sure Ms. Zwerner wins, then you're going to really push back on that. But again, in civil trials, you can really compromise based on the money, right? It's like, I think Parker should win. I think Zwerner should win. It's like, well, I think it should be $40 million. I think it should be 0. All right, let's give 5 or 10 or whatever it may be. You can kind of split the baby that way. Privacy concerns searching children. It's like, you can't possibly be making that argument here with the information Dr. Parker had. They don't necessarily go far enough to say they shouldn't have ever searched JT. They don't ever go that far. It's a red herring, and I think it's kind of gross how they explain, like, oh, we have privacy concerns with searching kids and searching people. It's like, yes, of course we do. People's rights need to be protected, and if their rights are violated, we need to fight against that corruption. We don't want to live in a country like that. But at school, with a reasonable suspicion of a gun in a pocket, you search the pocket. It's simple. And again, call me. Maybe people are going to be like, oh, this guy's a communist. He just thinks people should be searched whenever they want. It's like, I think there was plenty here. The way I see it, there was plenty here. The other teachers didn't take action. My expert's a real expert. Theirs isn't. Parker didn't breach any professional standards. She was not indifferent. Keep saying it's not foreseeable a 6-year-old would do this. Everyone was very surprised that this happened. Okay. She says, we win on the fault part, so you should never get to the damages. But let's hear how she argues the damages. Because as defense attorneys, even if you think you're going to win, just in case, you want to make sure there's not a big damages problem.
AT had been allowed to remain in the classroom and class instruction went on. That is what the local
I know this slide right before she talks about damages. There we go.
duty of care to Ms. Zwerner. She did not breach a duty of care, and that she was not grossly negligent. And it stops there. And you don't even get to damages. However, I need to talk to you a little bit about damages, and I'm going to tell you why. As you may recall, I questioned some of Ms. Werner's witnesses about her damages. And there was a reason I did that. Ms. Zwerner has come to this court asking for $40 million from Dr. Parker. And she told you that she cannot even open a bag of potato chips. And her counsel, he repeated that today.
All right, I've got to kick it up just a little bit. Sorry. I know this might be too fast for some people, but I got to run here in like 10 minutes. So, and I want to get to the rebuttal and the motion for mistrial.
As an officer of the court, and as my ethical duty to Dr. Parker, it's my job, unpleasant as it is, to come in and tell you there's a different side to that story. I'm an officer of the court. And so I questioned Ms. Zwerner and some of her witnesses about the fact that she has gone to cosmetology school, passed with flying colors, and is a licensed cosmetologist. And some of her witnesses have come in and said she only wanted to be a teacher, but I've shown you, if I'm admitted into evidence, are the texts that shows there's another side to that story too. And the other side to that story is that it was something, teaching was hard. And I'm not saying that to cast any blame on Ms. Zwerner, but to say she had thought about going to cosmetology school for years. So to come into the court and say, I only wanted to be a teacher, that's all I ever wanted, and now I can't, even though I don't think anyone testified she couldn't, I need $40 million. It's my job to tell you there's another side to that story.
It's always good when she's like really having to apologize about making this argument. Makes you feel good as a defendant. This is where she says, you know, Dr. Parker's going to have to pay or whatever.
She's withdrawn from the community. And again, I have to show you, when someone's asking $40 million from Dr. Parker, I have no choice but to say there's a
statement from Dr. Parker.
He objects. The judge overrules it. I don't think there was anything inappropriate about that. She is the defendant. Like, There might be insurance companies or somebody else paying in the background that the jury doesn't know about, but she's not garnering sympathy for Dr. Parker. I don't think. I think that was an appropriate argument from the defense counsel.
You're legislated from Dr. Parker, post counsel's argument.
Overruled. You may proceed.
I showed you the social media posts that Ms. Zwerner produced in discovery. She produced them to us. Flip through them. She's reaching out to international celebrities to go to the concert
What does that have anything to do with the damages? I don't get it.
9 months after the shooting. Again, officer of the court, duty to my client. I have to tell you the other
How many times is she going to apologize for arguing? Just do your job. We get it that it's your job, that you're an officer of the court.
side. It's my job. And that's why we brought you Dr. Hagen.
If I was on rebuttal and I want to be snarky, I'd be like, well, I don't know how many times the lawyer said she's got to do her job in closing. Don't you wish Dr. Parker would have done her job? I know Ms. Zwerner does.
Dr. Hagen explained to you what a forensic evaluator does when determining whether someone has PTSD. Dr. Watson came, as eloquent as he was not Ms. Werner's treating healthcare provider. He was a retained expert paid for by the plaintiff to talk about her damages. But he did not look at her treatment records from before the shooting. He did not see that there had been diagnosis of PTSD before. And Ms. Zwerner,
Totally fair criticism, in my opinion.
minimizing what happened to Ms. Zwerner. I'm not doing that.
She wasn't necessarily honest with the doctor. And again, she doesn't want to say, listen, I'm not saying that Zwerner hasn't suffered damage. You have to be careful of that. But just not to the tune of $40 million.
I'm doing my job. I have to bring
She's just doing her job, guys.
truth and the whole story. It's the brutal honesty that Mr. Beniozen stood up when we selected this jury and told you he wanted. I have to do it. This case has been a long road for a lot of people. Mr. Beniozen glossed over the evidence in the case, and I want to thank you for listening to me as I went point by point what happened at Richnut Elementary School on January 6th. I went through the evidence, you heard the testimony, you weigh the credibility, these are the facts. And I would submit to you that when you go back and you consider the facts and the jury instructions that the court gave you, I would ask that you find that Dr. Parker did not assume a duty to Ms. Zwerner. She did not breach a duty to Ms. Zwerner, and she most certainly was not grossly negligent or indifferent to Ms. Zwerner. What happened at Richnut?
Okay, it was a tragedy. Everybody agrees it was a tragedy. And then here we go with rebuttal. Let me answer a couple questions first. Michelle. So the admin wants to say, how could I have known because he was a 6-year-old? But when they say a teacher should have known, she had a concern searching him, but the teacher should have searched him, sword and shield. I really think what they're trying to say is nobody could foresee it. And it's proof that nobody else did anything either. I think that's the argument they're trying to make. But I think some jurors could see it exactly like you, Michelle, which is not good for them. Daybreak. The irony of this is I think if a child said JT has a screwdriver in his pocket, he said he would S me with it, they would have immediately, I think is what that's going for, searched him to take it away, potentially. I don't know. Dr. Parker, I don't know. The teacher could have sent the child to the principal's office. Does she not have that responsibility? Teachers hold no, that question would have changed outcome. Not 100% positive, but yeah, they argued she could have done a lot of different things and that she had done other things in the past with problems with students. All right, let's get to the rebuttal closing now. Tell me if you like this tactic that he pulled.
I get to go last. I'm going to be quick, I promise. Throughout the trial, every time somebody says something, that I am sitting there and I just want to jump out of my chair and scream and say, that's not right. That's not how it happened. I write note cards. I go at home, I write note cards, and I keep track of them. And I have note cards for every time that somebody said something and I just wanted to jump out of my chair. And I'm not going to go through all of them. I'm going to go through some of them, and I'm going to go through them quickly so that you can get back into that deliberation room, okay? All right.
A lot of lawyers do stuff like this. It's not my favorite. It's like they really want to drive home like, he was doing this contemporaneously throughout the trial, so it must be real. It must be good. It's like, fine, okay. I like the structure of it, so to make sure to hit points, but I will say sometimes when you do things like this, I know what I would do. I would probably rush through it. I'd be like, to make sure I can say as much as I can for all these note cards. I can do it with a pad. You can do it with a legal pad. It's like, listen, I highlighted all the times they said things that weren't correct. But now you're really doing these like factual dispute arguments, which again is the exact opposite of what he did in the initial close, which I liked better. This wasn't bad. This was fine, but we're going to get to the fireworks here in a second.
Testing day. Remember this? Testing day. Today was testing day. Ladies and gentlemen, if Dr. Parker took as much care for those tests and exercised, if Dr. Parker didn't expressly say to you, I'm going
to skip through some of them.
To protect you. What happened to this collaborative team approach that we're talking about? You want it to be a team? Every one of them, except for Dr. Parker. And Amy Kovac sends a text message 2 days after the fact. Amy Kovac was on that witness stand, and if you pull it up, did you know at that point in time that Dr. Parker was asked to search the boy at 1:40 p.m.? Did they ask him that? Did you know when you sent that text message that 2 other teachers came and asked her to search the person? Did they ask her that? Didn't want that answer. Did not want that answer. Because one person had all the puzzle pieces, and that person is Dr. Parker. And then you talk about going onto the playground. Going onto the playground. And what about what you did in the classroom? And why didn't you take them off the playground? And why didn't you search the backpack? The only reason they're able to point that finger of doubt at every single person in this school, except for Dr. Parker, is that Dr. Parker sat on her hands. At 12:21 p.m., if Dr. Parker was doing her job, she would have walked into that room, grabbed that book bag, and none of these questions would have ever been asked ever again.
I think that's an amazing point. By the way, just because I'm not a big fan of like the note card thing, the points he's making are A+ to me. Like that right there is a very, very good point. Peter, something's been bugging me. How did they get the text and Instagram messages from the plaintiff? Is that usual in civil cases? Thanks for all you do. Yes, part of discovery. Absolutely. If it's relevant to the case, relevant to the damages, if you say she can't do things and she's posting that she can't on social media, if she's saying that she always wanted to be a teacher, but you have text saying she wanted to be a cosmetologist, that's all fair game in discovery in civil cases.
And because she sat on her hands, they now get to point the finger at every other person at this school and said, why didn't you pick up the ball that I dropped? Why didn't you pick up the ball that I dropped? And then they talk about what Mrs. Zwerner could have done sitting in that classroom. I want you to look at instruction 23 when you get in the back, okay? Instruction 23 says, a plaintiff has the right to assume, that a defendant will exercise ordinary care until she realizes, or in the exercise of ordinary care, should realize that the defendant is not going to do so. What is that?
That's a great jury instruction. Great jury instruction and great use of it.
That means that when Mrs. Zwerner talked to Ms. Kovac, and they went and told the principal, who they knew it was her job to deal with a gun on campus, she had the right to assume that somebody was actually going to come into her classroom and do something about it.
Now, should she have realized they weren't going to come in her classroom and do something? Again, that's still an open question, but I think that's a really good, argument.
For every minute, she had the right to assume, whether it was in the classroom, on the playground, in the hallway, whatever, they had the right to assume that somebody was going to do their job and take care of her. And then they get up and say, oh, the expert's lying because she mixed up a guidance counselor with a teacher. But it's not just the expert that's lying. They're all lying. They're all lying. Ms. Kovac didn't tell you the truth. Ms. West didn't tell you the truth. Mr. Rawls, I think, sounds like they told you the truth a little bit. Ms. Zwerner didn't.
It is kind of funny, and that's always good when they say everybody else is lying, right?
Didn't tell you the truth. Everyone's lying. Everyone's lying. What does that tell you about common sense? They had days of evidence where you got to go home on Friday. Not a single person called. It was their turn. The only people they called as an expert were the people that they paid to come into this courtroom, and you're telling us that we're the problem for paying people? If anybody...
Okay. Just end it right there, brother. End it right there. That was a great point. The only people they called to testify that would come testify for them, they paid. Experts. End it there. End it there. Shocker. Or spoiler alert, I mean. He doesn't end it there.
Supported your position, march them onto that witness stand and tell us all the materials that Dr. Klinger reviewed, all the materials you reviewed, body camera, cops, witnesses. They help you? Put them on the witness stand. You didn't see a single one of them. You didn't see a single one of them. And if you didn't believe every word that was coming out of their mouth, and it's not exactly how it happened in your office, then get on the witness stand and tell us. There was all this conversation in jury voir dire about what it means to plead the Fifth Amendment. Ladies and gentlemen, somebody doesn't plead the Fifth Amendment unless they sit on that witness stand and say, I plead the Fifth. In a civil case, you don't have the right to remain silent until you actually exercise your right to remain silent. And not a single chance, they didn't want to take a single chance of her answering a single question. And if they didn't believe them...
Your Honor, I want to check at the stage. Sidebar, please.
No sidebar, overruled.
Then I would...
And the defense lawyer is correct to be upset about this. He's going to make a motion for mistrial. The judge is like, just chill. We're not going to do it in front of the jury, but it is timely. You didn't waive this issue for appeal, but oh, you hate to hear that. First off, I don't think it adds anything to their case. The jury knows she did not take the stand. Okay. And the issue is in civil cases, you are allowed to argue an adverse inference if the defendant takes the stand and pleads the Fifth. If they don't take the stand and don't plead the Fifth, it could be considered burden shifting that you're saying, they have the burden to take the stand. She has to take the stand and testify. They have to prove something, which is considered potentially burden shifting. But then you go a step further to bring up the fact that she would need to plead the Fifth. accusing her of a crime, potentially inappropriately using somebody's constitutional rights against them. Not good at all. Not good at all. I really think that was a huge misstep. Donkey Kong said, yeah, this case is done on appeal. Bro really just threw it in the trash right at the end. So if they get a good verdict, there's a lot of chances for settlement before appeal. The defense will have the leverage of the appeal. So maybe there'll still be some kind of settlement, which is also why you want $40 million. Maybe you settle for 10, whatever it may be. But that was really like out over your skis. Maybe you're feeling yourself, or you feel like you're crushing it. A really good case, or you're angry at Dr. Parker. You got to keep that in check. I don't think that was appropriate. Again, I'm not a Virginia law expert, so I'd have to look into it more. But in most civil courtrooms, that would be over the line and something that's inappropriate. Now, what could the saving grace be? That the defense brought it up in voir dire. He references that in that voir dire context. And and all of these jurors heard the defense talk about it in voir dire. And he gave a generalized principle as to how the Fifth Amendment works in civil cases, not saying Dr. Parker pled the fifth or whatever. Again, I'm trying to lawyer my way out of it, but it's a really big mistake. If I was the defense, I'd be pissed too. Unnecessary. The judge isn't happy about it either. We're going to hear the judge comment on it in a second.
I have to voice my objection on the record, Your Honor.
You can after closing. Go ahead, Mr. Leon.
And then we talk about Taylor Swift. Taylor Swift. What I want you to do is, if you watch that, if you look at that clip.
I'm going to skip ahead now to the arguments post-trial. But yeah, it was not great. It was a bridge too far, in my opinion. And now we're going to hear the arguments post-trial for the mistrial because of what we just watched. What did you think of the no card rebuttal? So yeah, I gave my comments on this, Rachel, but it was a good question. And then I did have a lot of thoughts on it.
Going to further instruct the jury, and then after I release them,
It is submitted to the jury.
I understand. That's what I'm doing. Okay. An important meeting and signed by your jury room in the law to your satisfaction. Trace person listed date and that's the same letter you now actor. All right. In the back, there is a couple other things we need to take.
All right, I'm going to jump ahead to when we get to these arguments here. Okay, jury's walking out, and here we go.
In this case, the standard is a manifest probability of prejudice. Two problems. In rebuttal, closing argument, plaintiff's counsel stood up here, pointed to my client directly, and asked the jury point blank to draw an adverse inference from the fact that she did not put on any additional evidence. This constitutes.
Yeah, the argument that he basically made was what you can do if the defendant gets up and pleads the fifth.
Burden shifting. The jury instructions tell the jurors, this is black letter law, that plaintiff's counsel, the plaintiff bears the burden by establishing by a preponderance standard each element that forms the basis of her claim. This is impermissible burden shifting. That error is compounded by the fact that Mr. Beniosen needlessly stood up here, again pointed directly at my client, and said that she didn't really invoke her Fifth Amendment privilege. She didn't invoke it whatsoever. She didn't put on any evidence. So it's fair game. You can draw an adverse inference against her because she elected not to testify. The problem with that, Judge, is in Virginia, I understand there's a distinction between the way the Fifth Amendment operates typically in the criminal context versus civil. And typically in the civil context, what has been addressed in the case law has been generally there's no blanket right to invoke your Fifth Amendment privilege. They have not addressed this in the context of testimony at trial. They've only addressed this in the context of pretrial discovery. And they've had instances where people have invoked the Fifth Amendment privilege as a way to not answer discovery questions. And they've held generally there's no blanket privilege. There's case law in other jurisdictions in the federal courts, Judge, that have held that under some limited circumstances, an individual can assert a blanket privilege, can assert the Fifth Amendment, and refuse to take the stand. And all the protections that come with that, the full panoply of protections, would come and would redound to my client's benefit. That would include 8.01-223.1, which is memorialized and enshrined this constitutional principle. That when someone faces jeopardy, legal jeopardy because of criminal charges, that for whatever reason she's got to proceed with the civil trial before the criminal trial, she should be able to exercise those rights. She should be able to protect herself from criminal liability, and she's done so in this case. This problem has been compounded repeatedly in this case. And
This argument, it says at the bottom, outside the presence of the jury.
opposing counsel could not help themselves but stand up here and rebuttal and take a cheap shot at my client by saying that she didn't really invoke her Fifth Amendment rights. We talked about it in jury selection, but it's okay. You can infer that she's hiding something. She has not carried her burden, even though it's my burden to carry by preponderance standards the evidence for each element. No curative struggle. No.
That was my next question. Hold on. So let me ask the question. Do you believe that a curative instruction that I had denied originally but had been offered is appropriate now?
I don't think a curative instruction would work here, Judge.
Okay, put those reasons on the record.
I'll articulate that. You can't unring the bell at this stage. Damage has been done. This trial is irreversibly damaged.
Okay, thank you.
Thank you, Judge.
Any response?
The invocation of a Fifth Amendment, even by statute, must be exercised. It was never exercised.
Then why did you bring it up?
Why did I bring it up?
Yeah.
See, the judge is like, why'd you bring it up, dude? But why wouldn't a defendant take the stand in a civil case? Well, for that exact reason. She was going to have to plead the fifth. She has open criminal charges. And they just wanted to avoid that, so it seems.
Because it was referenced, because she's in the situation where she hasn't taken the witness stand, and it's been invited to the jury in voir dire. Your Honor, we objected to the questions on the jury questionnaire, if you recall. I specifically objected to those at the time of the pretrial motion about the Fifth Amendment. I said, we cannot have that on here unless we know it's going to be invoked. And you, my memory is that you said, proceed, you're doing this, you're inserting this, as in they are inserting this. If that was never mentioned at all, things might be different. But the issue here is the inference that were hoping that the jury would conclude is that a Fifth Amendment privilege was exercised, and it wasn't. Not even in the absence of the jury.
Right. I agree with you. That's why.
It's just not. Just because it was led into the jury instructions does not mean that it's been inserted into the trial, and that they didn't make any inference. I didn't hear them mention it once during the trial, right? We didn't watch voir dire, but they didn't say anything to the jury about the Fifth Amendment throughout the trial. I hate to see it because this dude like crushed it. I thought he crushed it in this trial. But this is why being a lawyer is stressful. Everything you say in court, there's landmines everywhere.
I don't know why you mentioned it. So I'm going to deny the mistrial, but I am going to grant the limiting instruction, and I find that is appropriate at this time based on the arguments of counsel. So I will pull the one that was offered, and I will send it out for approval as the one that was offered.
Our objection to that is, again, the law states that the limiting instruction on that, the applicability of that code section, is in the event that somebody exercises their Fifth Amendment.
And you basically exercised it for her. I still don't understand why you even brought it up, but you did. So now we are where we are. So I'm going to offer the curative instruction. I understand your objection, and I understand plaintiff's objection as well, but I'm going to offer that as whatever the last.
Not great. Not great. And here's the thing that really sucks, I'll just tell you, is if this case does get a verdict at some point, it's not a hung jury, it's like you have this hanging over your head. I always hate that if I bring up any appellate issues in the case because it feels like we just did all this work. Could it get overturned? It gives them leverage, all sorts of problems with it, but we'll see what happens. We'll see what happens. I've got to run. You guys are amazing. Thank you for showing up. If we get a verdict tonight, I'll try to live stream it. If we get one tomorrow, I will try to live stream it. If you guys will all come and hang out with me during the live stream of the verdict, let me know in the chat. If you will, let me know by hitting that like button and making sure you're subscribed to our page. Before I run, the votes were in, and 3% of you said your verdict would be in favor of Dr. Parker, 97% in favor of the plaintiff. 9% said $0 to $1 million. I don't think they'd be happy with that. That's a pretty big percentage, almost 10%. 60% said from 1 million to 10 million. I don't think they'd be happy with, the low 1, 2, 3 million, maybe 10 million, and 28%. So almost a quarter of you said 40 million, give them what they're asking for or more. So that's always interesting to me. Vast majority of the chat would vote for the plaintiff as far as their verdict would go. I appreciate you guys so much. Hopefully I see you for the verdict. If not, till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.